So let's go to question 10 now. Which of the following is not an exception to the principle of indefeasibility under the BC Torrens system of land registration? And the answer is 4. An existing unregistered interest which will expire in 5 years. So that's not accepted. That is not exempted from the principle of indefeasibility under the BC Torrens system, that of land registration. An existing unregistered interest that will expire in 5 years, that will count under the principle of indefeasibility. The other things, these things are exceptions, like a reservation contained in the original Crown grant, a lease for a period of 18 months where tenant is in occupation, or the right of any person to show fraud by which registered owner derived his or her title otherwise than bona fide for value. 42. So, which of the following statements about the BC Torrens system are false? And the answer is 1, which is A, B, and C are false. And what are A, B, and C? A says trustees are shown on title as the registered owners of an estate or interest in land, with no indication of the existence of the trust, and beneficiaries are protected only by caveat registered on title. That is so false. And then B is false too. A charge registered on title is indefeasible. No. Charge registered on title is not indefeasible. And then we got C. Registered documents must be in the form prescribed by statute law to be enforceable between parties. No. Those are all false. A, B, and C are false. But this one is actually true. A caveat will automatically lapse 2 months after it is registered on title. So the answer for this question is, number 1, A, B, and C are false, because we're looking for the things that are false. Question 100. A fee simple owner in BC who is the victim of a fraudulent conveyance of his or her land will lose the right to have the transfer set aside when, and the answer is 2, the title to the property has been transferred to a good faith purchaser for valuable consideration. So the answer is 2. So basically, if somebody's been a victim of fraud, they'll lose the right to have the transfer set aside. What does that mean? It means it's going to happen. It's going to be transferred to a good faith purchaser. Number 2, the title to the property has been transferred to a good faith purchaser for valuable consideration. So in this situation of fraud, there's going to be compensation given to these people. I think it's from the insurance fund, isn't it? So 106, the principle of indefeasibility under the Torrens system means that a fee simple purchaser in good faith, what am I saying? Sorry. It means the principle of indefeasibility under the Torrens system means, yeah, that's right, number 1, that a fee simple purchaser in good faith is not required to investigate how the owner got his title. All right, so that's how the Torrens system works. So they don't really got to look, they don't got to do some research, dig up, find out how the person got the title. They don't need to. Principle of indefeasibility protects them. Then we got 211. Oh, and I want to read a little more about 106 there. It says, the principle of indefeasibility holds that a fee simple purchaser can rely on the title as being conclusive proof of ownership. Therefore, a fee simple purchaser can rely completely on what is shown on the registered titles and isn't required to investigate how the owner got the title. So, and I heard the news that there's actually people who are Torrens experts who go to, for example, they used to go to former Soviet bloc countries and help them to switch over to capitalist system, because capitalism, at least for sale of land, they require the assurance that what you're purchasing can't be kind of ripped off from you later on when they find out the title of the land belonged to somebody else. 211. The abolition of the doctrine of notice by the Land Title Act is subject to the exception of, and the answer is 2, fraud. All right, so let's just say that there used to be a doctrine of notice. That was canceled by the Land Title Act. The only exception to that is fraud. So fraud. 216. Which of the following statements about the principle of indefeasibility is true? And the answer is 3. In BC, there are a number of exceptions to the principle of indefeasibility. So that is true. The principle, in BC, 3. In BC, there are a number of exceptions to the principle of indefeasibility. Yeah, 260. Where a registered owner discovers that his title has been transferred by forgery to another person and registered in the forger's name. So what does forgery mean? Forgery means when you fake somebody else's signature and you use their fake signature to get something. So if somebody does that, they try to transfer the property on a form using a fake name, the name's not fake, but it's the signature's fake. So in 260, the answer is 2. He should file a caveat to prevent the forger from transferring the property to a bona fide purchaser. So basically, that's what happens when you realize that, for example, what if somebody took my apartment and they tried to fake my signature and transfer my apartment, not to themselves, but to somebody else for like $200,000, and they faked my signature. What could I do? Because I'm the registered owner. So I can do number 2. I can file a caveat to prevent that idiot who forged from transfer the property to a bona fide purchaser. Because, I'm in trouble if that happens, eh? 273. Earl is the registered owner of Blackacre. Duke forges and registers a transfer of Blackacre to himself. Duke then borrows $50,000 from Royalty Trust Company. The loan is secured against Blackacre by way of a mortgage. Holy crap. So what do we got here? So we got a place called Blackacre. Then we got Earl as the real owner, the registered owner. Then there's an idiot named Duke who comes along and he fakes Earl's signature. And he transferred this place called Blackacre to himself. And then he borrows $50,000 from this trust court company called Royalty Trust. The loan is secured against Blackacre by way of a mortgage. So, which of the things are true? And the answer is 3. Because of the forgery, Earl can recover Blackacre free of the Royalty Trust Corporation mortgage. So yeah, that's right. Because it's a forgery, Earl can get Blackacre back and just ignore the mortgage. 352. Which of the following is an example of a void deed at common law? And the answer is 4. All the above are examples of void deeds. So what are these examples of void deeds from 1 to 3? 1, it's a forged deed. If you fake a signature, the deed is bad. It won't work. And if you have a deed signed in circumstances where this party who signed it can plead non e factum. I don't really remember what that means, but I'm assuming that if they are got a mental problem, they can't sign. 3, a deed is given for illegal consideration. So these are the 3 samples of void deeds in common law. Forged, one is signed when non est factum. I think they don't know, they're drunk or they're mentally retarded or something, or it's illegal. That was 352. The answer is all of the above. Then we got 385. Which of the following statements is false? And the answer is 2. The principle of indefeasibility extends to charges registered against property. Nope. Indefeasibility does not touch any charges registered against property. All right, that's false. The other ones are true. Indefeasibility, it protects an innocent fee simple purchaser dealing with a registered owner of a fee simple interest, and the registered owner may lose an interest in land through the operation of principle of indefeasibility, even though nothing has been done to deserve the loss. Yeah, it could happen. If somebody fakes my signature, we could lose our house. Yep. But we will get our money back from the assurance fund. An exception to the principle of indefeasibility is a lease of 3 years or less when there's a tenant in occupation, and that's also true. But the thing that's false, and the correct answer is 2. The principle of indefeasibility extends to charges registered against property. All right. And the answer sheet said, answer 1 is true, as the principle of indefeasibility protects an innocent fee simple purchaser who deals with the registered owner. Answer 3 is true because rightful owner may lose the land to an innocent purchaser who dealt with the registered so-called forged owner. As answer 4 is true, as one of the exceptions, the principle of indefeasibility applies to leases under 3 years. So if it's under 3 years, the lease is not helped along. It doesn't benefit from any indefeasibility principle. But the answer 2 is false, as registered charges are not indefeasible. Charges aren't. 477. Which of the following is not considered a void deed at common law? And the answer is 1. A deed executed by a limited company, that is not considered a void deed. All right? If it's executed by a limited company, it's not void. It is, in common law, it is a go, green light. But these things are void. Forged deed, illegal consideration, when somebody pleads non-est, fuck them. You got it? So, if it's executed by a limited company, it's good to go. 555. In order for a person to make a successful claim against the assurance fund in BC, he or she must prove 3 of the following. Indicate the exception. Wow. The exception is 3. The person who deprived the injured party of his or her interest or estate in land has resold the interest to a bona fide purchaser for valuable consideration. Okay, so that's the exception. The person who deprived the injured party of his or her interest or estate in land has resold the interest to a bona fide purchaser for valuable consideration. So I guess that doesn't need to be proven. Isn't that nice? But you gotta prove that you lost an interest. You can't recover it by a court action, and the Land Title Act, if it hadn't been passed, it would have recovered the interest land by court action. That's the damn Land Title Act. I think they brought in the Torrens system, isn't it? Anyways, that is the exception, that you don't need to prove that the injured party of his or her interest or estate in land has resold the interest to a bona fide purchaser for valuable. Yeah, you know what I mean. And then we got 567. Section 14 and 18 of the Manufactured Home Act provide that no person shall move a manufactured home unless... Shut that kid up. The answer is 2. The manufactured home is registered in the Manufactured Homes Registry, and a transport permit has been obtained from the registrar. So there's 2 things. Number 1, talk's going to get wet. The first thing is that there is a book, or basically a computer registry, called Manufactured Home Registry. It's got to be registered there. And you have to have a transport permit. Those are the 2 things that the section 15 and 18.1 of the Manufactured Home Act says. So there. 569. There are 3 common types of void deeds, which are not considered to be a void deed. Too many of the same questions. The answer is 1, an unregistered deed. That's not void, unregistered. But the other ones, the forged, the illegal, and the non-est factum, those are all void. 614. In BC, under the Torrens system of land registration, If property is registered in favor of a trustee, this is shown by 3. A notation of trust on the title. So in BC, under the Torrens system of land registration, if property is registered in favor of a trustee, this is shown by 3. A notation of trust on the title. So on the title of a piece of property, there will be a notation of trust. Okay, that's 614. 713. A caveat is what? So a caveat is a notice for a notice placed on the land title register at the request of a person who claims an interest in land. So a caveat is, it's a notice. It's placed on the land title register at the request of a person who claims an interest in land. So say I want to claim an interest in some land, then I would put a notice on the land title register, and that would be a caveat. 9. 730. Which of the following statements about the common law doctrine of notice is false? So we're talking about the common law doctrine of notice. And the answer here, this is the thing that is false, is this doctrine is the basis of the BC Torrens system. Is not true. But these things are all true. Number 1, the doctrine holds a buyer to have notice of all reasonably discoverable interests affecting the property. 3, subject to certain exceptions, the Land Title Act has abolished the doctrine of notice in BC. That's true. So they don't have the doctrine of notice anymore. It's been abolished. It's been taken away from the land by the Land Title Act. And the doctrine of notice conflicts with the Torrens principles of conclusiveness of the register. So there you go. The common law doctrine of notice. The false thing about it is this doctrine is the basis of the Torrens system. No, it's totally at odds. Common law doctrine of notice is passé, and it's not part of the Land Title Act. It's not part of the BC Torrens system. 745. Before a transfer permit will be issued with respect to a manufactured home, the registrar must be satisfied that all taxes on the home have been paid. So you got to pay all your taxes, and then you can move your home. 794. Which of the following is not an exception to the principle of indefeasibility under the BC Torrens system of land registration? What is non-exception? And the answer is 3. A registered mortgage where the registered mortgagee effected register by fraud. So that is not an exception. If you've done it by fraud, then it is indefeasible. But these other things are not indefeasible, right? Lien for unpaid provincial taxes, a public right-of-way in favor of BC Hydropower Authority, or registered claim of builder's lien. All these things, they're effective. About a registered mortgage where the registered mortgagee affected, that is non-exception to the principle of indefeasibility. These other things are exceptions to the principle of indefeasibility. Because the fraud thing is at the center of the whole issue. Does it still happen? F me. 10. Page 10. 826. Which of the following is non-exception to the principle indefeasibility? Didn't I already do that one? Oh. Which of the following is non-exception to the principle of indefeasibility under the BC Torrens system of land registration? The answer is... They're asking the same question like many different ways. 3. A registered fee simple acquired bona fide for value without knowledge of an earlier fraudulent dealing in the fee simple title. So that's non-exception. That is actually at the core of the principle of indefeasibility. 856. Which of the following statements concerning the common law doctrine of the void deed is false? And the answer is 2. which is only B and C. Those are false. So B says a current fee simple owner, quote unquote, under a void deed has no remedy other than to seek compensation from the government and the forger from whom he has bought the land if he has lost his land title to its rightful owner. So no, there is remedy for that person. And C, a deed given in exchange for illegal consideration is not a void deed. That's false. Okay, so those two things, B and C, they are false. All right, anyways, 871, the other, just wait, I want to say 856. So what are the things that are true for the common law doctrine of the void deed? So remember, this is not the Torrens system. This is the old system. So the old system, rightful owner of the land whose title is transferred by void deed could retire. So you could recover if you did it within a 20-year period. And there's no certainty of title for the buyer land until the 20-year limitation period for lawsuits is recovered. So anyway, so basically that was the old system, common law doctrine of void deed. But nowadays we got the Torrens system, we got the Land Title Act. So B and C now, those things which are false, that they didn't have a remedy, and the illegal consideration is not a void deed. Anyway, so it turns out that those things are changed around, and they do have a remedy, and the void deed is not void anymore. That's the Torrens system. 871. Which of the following statements regarding manufactured homes registration is false? And the answer is 4. If an owner discovers that his or her manufactured home is not registered, he or she must register the home within 30 days of that discovery. So that's what you got to do. You got 30 days if you find out, wow, my mobile home is not registered. Well, you got 30 days to get that remedied. 896. Which of the following is not a component of the BC land title registration system, which is Torrens, by the way? And this is not a component, and the answer is 2, the doctrine of the void deed. That is from the old common law system, but now we got the assurance principle, the abolition of the doctrine of notice. There's no more of that, and there's no more indefeasibility of registered fee simple titles. So the doctrine of the void deed is the answer, because that's not a component. That's gone. That's under the old common law system. 939. A clerk in the land title office mistakenly registered a fee simple transfer on the wrong title, with the result that Lot 5 owned by Michael was transferred to Scott. Scott discovered this error and had a party. Instead of correcting the error, he sold the property to another person who was unaware of the clerical error and of Scott's dishonest conduct. So, whoa, Scott is a bad dude. Glad I changed my name. Michael discovered the error after the buyer had registered the transfer from Scott. He wants his land restored to him and the register corrected. You correctly advised Michael that. Sucks to be you. Owned by Michael. Well. Alright. So the register, they're not going to correct the register. And Michael contributed to his own loss by neglecting to register a lien on his title to indicate to anyone searching title that he was a registered. No, he didn't have a reason to put lien. None of the above say is correct. No, that's also false. So my answer, the real answer is the person who bought the property bona fide and for value from Scott is protected by the BC land title system, which is Torrens. As a result, Michael can't have his property restored to him. $980. Andrew forged a mortgage, registered it against the fee simple title of Julia without her knowledge. Andrew then went to the handy-dandy finance company and sold the mortgage to them. Wendy, an employee of Handy Dandy, searched the title and ascertained that Andrew was the registered mortgagee prior to buying the mortgage from Andrew. Subsequently, Julia learned of the mortgage when Handy Dandy sent notice of her, instructing her to make payments in future to Handy Dandy. Wow. Julia told Handy Dandy that she never granted a mortgage to anyone and that she has no intention of paying them anything. Andrew's now living happily in Bolivia. What? Which of the following statements is true? 984. So the answer is 4. Julia will be able to have Handy Dandy's mortgage removed from her title, and Handy Dandy will have no recourse except against Andrew. So that's the situation. She can have it removed from her title. Good. That's the one, I think, exception of the Torrens system, right? And Handy Dandy will have no recourse except against Andrew. They'll have to send some hitmen to Bolivia and hit women. Hit them. Take them to court. 993. Which of the following is not one of the 4 basic principles of the BC title registration system? It's not. And the answer is 2. The doctrine of the void deed. That's not part of the Torrens system. But indefeasibility, registration requirement, and abolition of notice, those are all principles. And there you go. That's the end of